Very good. I think the numbers have now stabilized. Well, good morning, everybody. Thank you very, very much for joining this latest hot topic webinar from Wilberforce Chambers concerned with the latest installment of the Safeway and Newton litigation concerning equalisation. If you have any questions you'd like answered, can I direct your attention to the lower bar of the Zoom screen, and you'll see that there's a Q&A button that you can press. And if you type up a question, then we'll endeavour, if we have time at the end, to get Seb in particular to answer it. For that, thanks very, very much. So here we are, Safeway and Newton, latest instalment. You'll all be appreciating the fact that we've had a remarkable timescale from Barber, which was decided 30 years ago. It's the 30th anniversary of Barber this year. For this matter to actually come before the court as if possibly the final instalment in the resolution of Barber type questions, but who knows, never say never, as I think the Safeway case itself may demonstrate. But it's not just 30 years from Barber, it's 24 years since the 1st of January 1996, when Section 62 of the Pensions Act 1995 entered the statute book, and yet in those 24 years, there hasn't been a single decision on the meaning and effect of the introduction of a, quotes, equal treatment rule into all English pension schemes until now. And of course, it's 14 years to the month since Mr. Justice Warren's decision in Harland Wolff, the domestic law decision, which brought home the existence of the problem which led to the Safeway and Newton litigation. Look, as is well known, the underlying problem which has caused so many pension schemes difficulties over the years arose out of the post-Barber practice of announcing changes to NRD in relation to future service, and then following up years later with an amendment deed, retrospectively confirming that which had been announced. Now, as a matter of domestic law, pre-Section 67 of the Pensions Act 1995, so pre-6th of April 1997, if the scheme amendment power did not include a proviso protecting accrued rights, and a not insignificant number of scheme amendment powers did not include such a proviso before Section 67, it was perfectly possible to have a sweeping up formalising amendment and for NRDs to be retroactively formally increased accordingly. Harland and Wolff is really what brought home the existence of a problem in this area, because it held that one of the post-Barber equality cases in the ECJ, and it really was only one, Smith and Avdell, had decided, or rather had implicitly decided, that this was not possible. This practice of retroactive amendment based on a pre-existing announcement was not possible. In Harland and Wolff, Mr. Justice Warren interpreted Smith and Avdell as imposing a restriction under EU law against retrospective amendments levelling down, even though, as a matter of domestic law, the rights of the advantaged class, as well as the rights of the disadvantaged class, were equally susceptible to being treated in that way. There was a certain irony to this because the line of authority, such as it was, that Mr. Justice Warren relied on, the Smith and Avdell case, never needed to, indeed never should have come before the ECJ at all, as regards the particular issue which Mr. Justice Warren then relied upon in order to decide the case of Harland and Wolff. As is well known and was referred to by the Court of Appeal in Safeway and Newton, Smith and Avdell went directly from the Industrial Tribunal in 1992 to the ECJ, and it did so by agreement of the two counsel who appeared. There was no debate as to whether the issue should be decided as a matter of domestic law at all. And furthermore, all of the counsel who appeared in Smith and Avdell, both at the Industrial Tribunal level and in the ECJ, all of those counsel, or I should say none of those counsel, was pensions counsel. All of those counsel were from the employment or European or public law end of the market. And I don't say that in any way dismissively or arrogantly as regards the monopolies of truth or expertise or excellence that the pensions bar have. No, that's not the point. The point is, if you look at Smith and Avdell in the Industrial Tribunal, no one actually drew attention to the terms of the amendment power. There was no focus on the terms of the amendment power at all. There was no focus on the fact that the amendment power in Smith and Avdell, in the Avdell scheme, did not permit of retrospective amendments affecting accrued rights. That amendment power included a courage proviso, which precluded the retrospective levelling down of benefits which the amendment in Smith and Avdell had purported to make. In Smith and Avdell, the amendment was purportedly made on the 1st of July 1991. In Barber terms, that created 3 periods: a pre-17th of May 1990 period, a 17th of May 1990 to a 30th of June 1991 period, and the 1st of July 1991 onwards period. The fact is that as regards all service accrued prior to the 1st of July 1991, as a matter of domestic law, the amendment that was made in Avdell was ineffective. And so if Avdell was going to go to the ECJ at all, it should only have gone to the ECJ on the question of whether for future service, for the period of accrual from the 1st of July 1991 onwards, the levelling down of benefits was valid. So wholly ironic, as it were, history to the emergence of this particular issue. Now, it's taken the Safeway case to go all the way through the High Court, to the Court of Appeal, to the CJEU, and back to the Court of Appeal to get to the bottom of these issues. And I appeared with Seb in the High Court, in the Court of Appeal first time round, and in the CJEU. Seb, to his credit, appeared alone in the Court of Appeal on the most recent occasion. And of course, in the Court of Appeal on the most recent occasion, that was the first and only occasion that Safeway actually won. And I'll leave it to you to draw your own conclusions as to the merits of having bothered having me at any stage in the lower courts or indeed in the CJEU in the process. So Seb is very much the man of the moment. And with that, I'll hand over to him.
Thanks, Brian. I think before moving on to Safeway, it might be worth just saying just 2 more short things about Harland and Wolff, because as you say, Brian, that is the real problem that was created for all retrospective amendment purporting to level down during the Barber window. And it was one of those decisions that the industry, I think, has long held to have been wrongly decided, but it had just become so established that it had been effectively accepted. And I think that apart from its reliance on Smith and Avdell, which is the point you raised, Brian, I think the 2 other points that have caused a certain amount of suspicion as to the accuracy of that decision are first what was called in that case the ratchet effect. And just to explain that, the effect of the Harland and Wolff decision, let's take the facts of Harland and Wolff. You had NRDs of 60 for women and 63 for men. And those benefits were accruing on a defeasible basis because they were capable of being taken away by retrospective effect of the amendment power. So if it's right that Article 119 means that you cannot take away benefits accruing during the Barber window, then you get this deeply perverse effect whereby the benefits of the advantage class, which were NRD 60 defeasible benefits, become NRD 60 indefeasible benefits because they can't be taken away. And the benefits of the disadvantaged class, which were NRD 63 defeasible benefits, become not just NRD 60 defeasible benefits, but NRD 60 indefeasible benefits to reflect the now increased advantaged class benefits. So by this ratchet effect, the benefits of the disadvantaged class and the advantage class become better than the previous benefits enjoyed by the previous advantage class. So This was an obvious difficulty with the decision in Harland and Wolff, because Article 119 is clearly talking about granting equal benefits, not better benefits, which was the net effect of Warren's decision. So that was problem one. And the second problem with Harland and Wolff was that Mr. Justice Warren, to his credit, acknowledged this difficulty and accepted that benefits were defeasible. And he accepted that they were therefore subject to other provisions in the scheme governing documentation, such as the forfeiture provision and even the retrospective power of amendment. But what he said was that it was only subject to being taken away defeasibly or retrospectively, provided that the amendment power was not used for the purposes of equalisation. And it's never been particularly clear what that means and whether it envisages some factual inquiry as to what the purpose of the amendment was and the reason for the benefits being changed. But the reason I sort of raise this oddity is, I don't know if Brian remembers this, but it was that oddity that was the genesis of the Section 62 point, because we were sitting in your room, Brian, I don't know if you remember, but we were sitting in your room and we were debating how to approach Harland and Wolff and how to approach the issues in Safeway. And you said to me, well, you had this eureka moment. You said, if the limiting factor is for the purposes of equalisation, we can get around that, because Section 62 in our case, not in Harland and Wolff, Section 62 was introduced and that equalised. So all the 1996 deed did in Safeway, all the later deed did in Safeway, was reduce that which had already been equalised. So that was the origins of the point. And of course it took on a life of its own as the case developed, but it wasn't much of a jump when you started seeing Section 62 as being about equalisation and having the effect of equalising, to then jump from that to saying it had the effect of closing the Barber window, which is how it then got deployed in the Court of Appeal and was accepted by the Court of Appeal. So that, I think, neatly takes us on to Safeway itself. Now, most people will be pretty familiar now with the litigation. It's been going on for quite a few years, but just as a brief recap, it has all the factual hallmarks of the failed equalisation cases that Brian described at the beginning. You had the 60 NRDs for women, 65 NRDs for men. You had a series of announcements in 1991 in reaction to Barber, stating that the NRDs of all members would change to 65 from the 1st of December 1991. And the scheme was then simply administered on that basis ever since. Now, as is often the way, the power of amendment required a deed to effect any changes, but that power of amendment did, unlike Smith and Abdul, permit to be backdated to an earlier point of an announcement. So they were accruing on a defeasible basis during that period. The next official deed for the scheme wasn't until the 2nd of May 1996, the 1996 deed, and that was your normal sweep-up deed that was trying to incorporate all the changes that had taken place by announcement during that period. And that deed was stated to have retrospective effect as far as NRDs were concerned, to the 1st of December 1991, in accordance with the announcements that had been made. So without going into the full history of the litigation, there were essentially three arguments that were being run throughout. We had a construction issue, which was that the measure closing the Barber window was, as a matter of construction of the amendment power, the 1991 announcements. That turned on the wording of the specific wording of the power of amendment and didn't really go very far. But the second, more interesting point was what we called the Harland and Wolff issue, which is we were saying, look, Harland and Wolff was wrong. The measure closing the Barber window was the 1996 deed, but it did so retrospectively to the 1st of December 1991. And we disagree with Harland and Wolff that that's prohibited as a matter of EU law. And the third issue was Brian's Eureka issue, the Section 62 point, which is that the measure closing the Barber window was the introduction of Section 62 of the Pensions Act 1995. So each of those arguments had a different measure closing the Barber window. And obviously when we found we had Mr. Justice Warren at first instance, we weren't particularly optimistic at getting him to agree that he had decided Harland and Wolff wrongly. So we really set our focus from then on the Court of Appeal. And the Court of Appeal did take a rather different approach at the first hearing, particularly on the interpretation of Smith and Avdol, the Court of Appeal had quite a bit of difficulty, I think, with the ratchet effects problem that Harland and Wolff exposed, and the idea that Article 119 could require that members be given better benefits than the previous advantaged class. What the Court of Appeal said was that you couldn't say with any confidence that Smith and Avdol stood for the proposition which Harland and Wolff said it stood for. So you couldn't, with any confidence, say that there was a prohibition under EU law on benefits being retrospectively levelled down where the benefits accruing during the Barber window were defeasible benefits. And the main reason for that, they said, was that the benefits, as Brian's pointed out, in Smith and Avdol were not defeasible. Now, I noticed Brian explained to you why no one looked at the amendment power, and he explained to you that there's no reference to the amendment power in the industrial tribunal, there's no reference to it in the decision of the CJEU. What he didn't tell you is how we managed to get our hands on the amendment power. And Brian, I think you really have to tell that story, because it's one of my favourite stories from the case. It's quite an unusual confluence of events, if I remember. You're going to have to tell that story.
Okay, I wasn't entirely expecting it, but that's well, yeah, okay. So as Seb says, one of the many mysteries about Smith and Avdol was that the amendment power wasn't referred to in either the Industrial Tribunal or its terms, or in the CJEU. We were a bit puzzled reading the Industrial Tribunal as to how the amendment had actually happened in Smith and Avdol, because I think it's right to say that in the Industrial Tribunal, they'd simply referred to an announcement on the 1st of July, 1991, and what the effect of that was. And we began to wonder, since it referred to an announcement, whether, frankly, the Barber window had been closed at all in Smith and Avdol. And so I remembered that some 10 or 15 years earlier, I had written an opinion on the Avdol pension scheme. And I remembered who my instructor solicitor was, and I knew that they were very nice and very approachable. And so more in hope than expectation, and with no little chutzpah, I rang up the solicitor and said, you may recall I advised on the Avdol pension scheme. This is what I'm doing at the moment. Any chance of having a look at the Avdol amendment power? And the solicitor in question said, well, that's very, very amusing, because I've got your opinion of 10 to 15 years ago open on my desk at the moment, because I'm doing something concerning the prehistory of what is now a quite different pension scheme, and Avdol comes into it. And that person very kindly gave us a copy of the power. Mercifully, the power was actually exercisable by announcement. But on looking at the power, we almost fell off our seats, because we saw that there was actually this sort of courage proviso in the power, which prevented its being exercised so as to take away accrued rights. You know, that actually caused a bit of embarrassment, because I began to wonder whether, what was I going to do with this amendment power, because I had a duty to Safeways to deploy it if I could. Because it was now within my knowledge. On the other hand, I couldn't really deploy it, you know, without the permission of the solicitor who provided it to me. And in a sense, I had an enduring duty to Avdol not to mess up their pension arrangements. Anyway, mercifully, that resolved itself too, as I recall, because it turned out that the history of the way the Avdol scheme had developed and further schemes had replaced it meant that the accrued rights point was of no materiality. And so we were free to deploy it. I think I've got that right, Seb. We were free to deploy it in the Court of Appeal on that basis.
Yeah, sorry for dropping you in it, but that's my recollection too, which was obviously critical, because armed with that power, the Court of Appeal felt confident that there needed to be a reference to the CJEU, which is of course where we then went, and we weren't particularly optimistic that the CJEU would really grapple with the technicalities of defeasibility, which is a fairly chancery law type concept. But what the CJEU did decide was that the key question in each case is, when did the Barber window close? And the answer given by the CJEU, in this case, much more clearly than it had previously articulated the points, was that the Barber window did not close until a measure was introduced into domestic law that brought about legally enforceable rights and remedies to Article 119 compliant benefits. So picking up the the language of the previous equality cases prior to the date of those measures being introduced, so either past or period 2, Article 119 required the benefits of the disadvantaged class to be levelled up, as we knew, but the extra gloss was that they could not then be reduced even if the benefits of the advantaged class accruing during that period were themselves defeasible, on the basis that in the absence of Article 119 having been implemented into domestic law, those rights formed the only valid frame or system of reference. But, and crucially but, once that measure had been introduced, once legally enforceable rights and remedies appeared in domestic law, so i.e. the future, or period 3, then all that Article 119 required was equal treatment, and it was a matter of domestic law policy as to what the level of those benefits ought to be. So contrary to the Court of Appeal's instincts, the European law, the ECJ-EU did confirm that there was this retrospective, this prohibition on retrospective reductions of benefits accrued prior to the introduction of the measure, and that was the case even if the benefits accruing during the Barber window were defeasible benefits. Now, I know I'm biased on this, Brian, but the ECJ-EU didn't get that right, did they? The defeasible bit, I mean, the rest of it was just equality cases, but the defeasible bit, they didn't get that right.
Well, they didn't engage with it at all, is the truth. But look, it was a collision of two cultures, wasn't it? It was the English chancery end of pensions practice, the idea that the advantaged class only had defeasible benefits, the sort of notion that defeasible pay, in a sense, because after all, the whole Barber analysis is based on the equivalence of pension rights and pay, that this notion of defeasible pay was somehow something that Lord Briggs and we could get our minds around. But on the other hand, when you got to Europe, it almost was, they wouldn't see it, I think. So it was, as I say, a collision of two cultures. It was our culture and it was the European culture, which was to look for concepts of legal certainty and to say basically that employees are entitled to know exactly where they stand at any given time, insofar as they are relying on EU law rights, which are conferred by Article 119. And it's all very interesting for you to talk about defeasible rights, but Article 119 is about people knowing where they stand and where they stood as of the 1st of December 1991 through to the 2nd of May 1996, was they had, pursuant to Article 119, NRDs of 60, and that was the way they saw it. But it was a very, very frustrating experience, the CJEU, and I dare say that pretty well everybody who's on this webinar has had a similar frustrating experience of appearing in front of the CJEU. But what was specifically frustrating about our experience was that most of the very limited airtime that they give to you in the course of a hearing, we know it's 15 minutes per side, subject to questions that they ask. Most of the airtime that they gave in the hearing was given to counsel, in-house counsel from the European Commission, who had a wholly idiosyncratic view of what was a measure for the purposes of EU law, and insisted on contending to the court that the issue that they needed to grapple with was whether the announcements which had been made as of the 1st of September and the 1st of December 1991 constituted a measure, when Safeway had made absolutely clear that if it lost the question of construction in the Court of Appeal, the point was that there was no measure until the 2nd of May 1996. What needed to be addressed was whether that measure was effective against the backdrop of benefits of the advantaged class being defeasible throughout. So we had expressly abjured any such submission in the Court of Appeal. The reference from the Court of Appeal had made absolutely clear that the issue was based on the 2nd of May 1996, deed being the measure, and yet we had all this time wasted by, I have to say, I should be forgiven for saying, utterly pointless and diverting submissions, which meant we didn't really get a proper chance to get our case across, not that it would have made any difference, frankly. But what was particularly disappointing about the decision was that it didn't really engage, as Seb says, with the with the issues as we had seen them and as the Court of Appeal had identified them, and actually as they referred them to the CJEU. What happens, I mean, many of you will have read the CJEU's decision. They can basically just assume that Smith and Avdell was rightly decided, that Smith and Avdell stands for the proposition which is before them, and therefore game up. That there was no reference to the fundamental EU law principle that for the purposes of identifying the rights of the advantaged class, the sole point and exclusive point or frame of reference is the rules of the scheme. No reference to that at all, because of course on that argument that the sole and exclusive point of reference is the rules of the scheme, the answer is, well, yeah, and under the rules of the scheme, these benefits are defeasible. There was no consideration of what we considered to be the most pertinent of the equality cases decided in 1994, which was a case called Fisher, which had made absolutely clear that Article 119 was about giving the disadvantaged class the same benefits as the advantaged class, not better benefits. Made absolutely clear. Submission made, completely ignored. And in that connection, there was no discussion at all of the ratchet effect, no discussion of the fact that women were being made better off by this decision, and that men correspondingly were being made better off than the women were originally. No discussion of that at all. Now, does that make the decision wrong? Well, A, who are we to say, and B, well, look, back to the clash of cultures. It doesn't make the decision wrong, it just makes the decision rather frustrating from a standpoint, I think.
Yeah, I can see that. Which I think takes us then quite into the final chapter, as it were, of the Court of Appeal hearing, where this was the issue that was left over pending the outcome of the CJEU hearing, the Section 62 point itself, so the latest development. And where the CJEU decision left us in practice was that if the measure was the 1996 deeds, the Barber window only closed on the 2nd of May 1996. And so the 1996 deeds was invalid in its attempt to reduce NPAs to 65 for any period prior to that date. So without more, that was effectively game over for Safeway, but this is where the Section 62 point came in to give us some reprieve from that rather stark position. But the question, the legal question, was still, when did the Barber window close? But the answer that we were putting to the Court of Appeal was that it was closed not by the 2nd of May 1996 deed, but by the introduction of Section 62 of the Pensions Act with effect from the 1st of January 1996. And what that meant, we said in our case, was that the benefits accruing between the 1st of January 96 and the 2nd of May 96 accrued after the measure bringing domestic law into compliance with EU law. And so, consistently with what the CJEU had said, we argued, there was no EU law prohibition on those benefits being retrospectively reduced by the 1996 deed in accordance with domestic law. Now, although it's a small window, 1st of January 96 to the 2nd of May 1996, it was still worth quite a lot of money from Safeway's perspective. And as we know, the Court of Appeal accepted that submission. But I don't know if you found this, Brian, but most people I've spoken to so far about the case have said that can't possibly be the effect of Section 62. That's got to be wrong. I think the main difficulty that people have had with the decision is the fact that Article 119 already had direct effects in domestic law within the UK. So how can it be that Section 62, which simply reflects the direct effect of Article 119, can change anything? So how can it close the Barber window when the direct effect of Article 119 didn't close the Barber window? It's the direct effect of Article 119 that opens the Barber window. I think it's really that conceptual problem that I think is where a lot of people think it wasn't the right decision. But what I thought I'd do is just go through the three main limbs to the submissions that we made to the Court of Appeal, and which were accepted by the Court of Appeal, and just to see if we can satisfy some of the doubters on this and why it is the Court of Appeal reached the decision that they reached. So there, as I said, there were three limbs to it. The first was probably the least controversial. We said, look, the first point is that the domestic law effect of Section 62 was to introduce legally enforceable, equalised benefits for members of occupational pension schemes, and thereby implementing into domestic law, and I'll say those are the key words, into domestic law, bringing domestic law into compliance with Article 119. Well, what Section 62 says, as we know, is that an occupational pension scheme which does not contain an equal treatment rule shall be treated as including one. So it was the first time, we said, that the benefits under an occupational pension scheme had been brought into compliance with Article 119 across the board. So prior to that point, harmonisation was only being achieved on a case-by-case basis by the actions of individual schemes. And that's what's given rise to the litigation that we've experienced over those many years. But after Section 62 was introduced, harmonisation was immediate and it was universal, because the substantive benefits of every scheme across the country were changed to ensure equal treatment. And importantly, the effect of Section 62 was not in any way conditional on any other step being taken. Nothing else was needed to change members' substantive rights. The section doesn't say that the rules shall be treated as amended subject to further textual amendments. So the legislature was not leaving it up to the individual scheme to decide when and whether to confer equal rights on men and women in compliance with Article 119. It was telling them that the rules stand amended so that they are in compliance with Article 119. So it was no different, we said, analytically, from a situation where the scheme had entered into a deed on the 1st of January 1996, simply inserting the same equal treatment rule that's prescribed by Section 62. There could be no question that in that scenario, the Barber window would have closed with effect from the 1st of January 1996. And yet Section 62 is having exactly the same legal effect. And the fact that it was being imposed by statutes rather than being achieved through the amendment power cannot be the difference between the Barber window closing and the Barber window not closing. So that was point one, the domestic law effect of Section 62. The second point was that the implementation of Article 119 in that way satisfied the litmus test for what constitutes a measure under EU law in terms of legal enforceability. Now, this was a happy byproduct of the oddity that Brian described to you about the role, the intervening role of the Commission. Because the Commission went slightly off on a tangent and tried to cast doubt on whether the 1991 announcements were in fact the measure, or at the very least reduce the retrospectivity of the 1996 deed, it forced the CJEU and the Advocate General to engage with what was it under EU law that was required in order to close the Barber window. And it was in that context that the Advocate General said at para 33 that the date on which the Barber window closed is the date that the measures which are fully legally enforceable are taken to equalise the NPA of men and women. So the litmus test was legal enforceability and effective remedies. And none of the previous CJU cases have made it as clear as that that's the threshold that had to be crossed. And what that indicated was that the form the measure takes isn't important. What matters is the substantive effect. So it doesn't matter whether it's a textual amendment, a piece of legislation, or some other recognised mechanism under domestic law of the member state. It's about ensuring enforceability and the effective remedies. So that was the second point. The third point, which I think is the key one for satisfying the doubters, is why is it that that is the litmus test? Why is it that legal enforceability matters? And the answer as to why it's significant to EU law is that it marks the movement away from what is known in the equality cases as the second period, which is the period when, because of non-compliance of domestic law, Article 119 is required to supply the rights and remedies where equal treatment is infringed. So it marks a transition away from that and towards the third period, where those rights and remedies are supplied by domestic law. And so Article 119 has no concern at that point with the level of pay that members are receiving, provided they're being treated equally. So the starting point for that submission is the recognition of the basic point that the obligation under Article 119 is on member states to ensure and maintain equal treatment, as spelt out in Article 119 itself. And that the jurisprudence surrounding Article 119 was then concerned with the position within EU law pending the member state bringing domestic law into conformity with Article 119. And it was in that context that Article 119 was held to have direct effect in the famous Defrenner case. And it was in that context that the equality cases decided that where discrimination exists and domestic law hasn't been brought into compliance with Article 119, the rights and remedies provided by Article 119 were to leveled up benefits to put the disadvantaged class in the same position as the advantaged class. But that obligation only exists for so long as domestic law fails to comply with Article 119, so that it's incumbent on Article 119 to provide the rights and remedies with direct effect. And whilst nothing has spelt it out as clearly as that, there were hints to that effect in some of the earlier cases that predated the equality cases, and particularly the case whose name I can never pronounce, so I just call it FNV, and the Kowalska case and NIMPS. All of those were pre-equality cases, and they all said that the obligation to level up was being imposed until such time as the national government adopts the necessary implementing measures. And it was this levelling up obligation that the equality cases then cite and adopt. So your Collerall, your Smith and Abdul, your Van den Akker, all of those cite those paragraphs from NIMPS and Kowalska. So what we said was, look, the consistent point being made in EU law is that Article 119 steps in to provide the rights and remedies, at the risk of repeating this, but I want to really get this point clear, until the point when national law is brought into compliance with EU law. Because after that point, rights and remedies are provided under domestic law in accordance with domestic law policy. So in the meantime, during period 2, where Article 119, rather than domestic law, is forced to supply the rights and remedies, it can only do so by reference to the position of the advantaged class. But once domestic law is brought into compliance, the obligation under Article 119 is satisfied. And so Article 119 isn't concerned anymore to fill the vacuum. And so what we say is, look, that's why Section 62 and its introduction was so significant, and why it is substantively different than just the direct effect of Article 119. Because it marked that transition towards UK law compliance with Article 119. It supplied for the first time legally enforceable domestic remedies, so that Article 119 didn't have to. And it meant that from that point on, provided members were treated equally, the level of pay was determined only by domestic law policy. And of course, as we know, on the facts of this case, it was, as a matter of domestic law policy, still permissible, as at the 2nd of May 1996, to reduce members' benefits with retrospective effect. So where that left us, as an argument, was that on ordinary severance principles, the 1996 deed, whilst invalidated to the extent it purported to reduce benefits during the Barber window, so before the 1st of January 1996, it was not invalidated to the extent it purported to do so from the period of 1st January 1996 onwards, because that period was the period after the Barber window had closed. Convinced, Brian? No? Yes?
No, I've got to say absolutely, and you've put it so persuasively, you've certainly convinced me. Look, I mean, obviously Section 62 gave Safeways a lucky escape. It saved them a few bob. I think for all of us, or certainly those of us on this call who have been over many years utterly frustrated by the way that English law has developed in this area, it's at least nice to get some good news at the end of the line, because the fact of the matter is, as we know in this case, as in so many other pensions cases, the members were getting a windfall. They've still got a windfall, but it's a slightly less extensive windfall than they would have had otherwise. But the question then is, what's the practical effect of this decision? And the answer is, I think, although the 142 of you who've been on this call have stayed with it this long, the answer is very, very limited indeed. It's very interesting, but very interesting indeed, but its practical effect, very limited. Look, it applies, as you know, essentially to cases where amending deeds were made during what we've come to refer to as the Safeway window. The Safeway window is the period between the 1st of January 1996, when Section 62 came into force, and the 6th of April 1997, when Section 67 came into force. And it's a further irony, to add to the levels of irony in this particular case, to note that if Parliament had brought Section 67 into force on the same date that it brought Section 62 into force, and I know there are a whole host of historic reasons why it didn't, but if it had done, then there would be no such thing as the Safeway window, and there'd be no such thing, at least as the second of the Safeway cases. But if you did execute a deed of amendment purporting to have retrospective effect between the 1st of January 1996 and the 6th of April 1997, and if you didn't have a courage or other accrued rights type proviso inhibiting the exercise, then Safeways 2 has now told us that that was a valid exercise. Now, of course, as we know from experience, most schemes which even those which did make announcements had made their amending deeds before the 1st of January 1996. There are very, very few cases that one encounters in practice where you come across an amending deed which postdates the 1st of January 1996, and that further cuts down the number of potential cases where employers, where companies can actually benefit from the decision. And of course, the further point still is that this is, in a sense, all rather old news. And although it may well be that there are cases out there where companies and trustees did exercise amendment powers retrospectively between the 1st of January 1996 and the 6th of April 1997, whether they now have the appetite to reopen things in order to take the benefit of Safeway 2 is obviously a fundamental, practical and realistic type question. For Safeway, obviously, for whom this issue had been kept live for year upon year upon year, kept live since 2009 when the issue had first emerged, it's something that Safeway can now take advantage of, because they had not been paying pensions on the basis of an NRD 60 equalisation between the 1st of January 1996 and the 6th of April 1997. So Safeways can take the benefit of it. Whether there's anyone else out there who can or would have the appetite to do so may perhaps be doubted. But as I say, I think it is really interesting, and it may be the last in the line of equalisation cases ploughing this particular furrow that any of us have to consider. Though, as we all know in this area, you should never say never, because there's always something that comes around the corner to actually surprise you. Now, that we've got to 11:46. I do have 3 questions. Seb, can you see the questions?
I can, yes. Clicked on the right button.
2 of them, unsurprisingly, and he won't be shy in my mentioning this, come from Mr. Tim Cox. Thank you for that, Tim. The first question, I'll read them out, is: was there any argument that the deed should be read as achieving its intended effect by reducing pre- and post-Barber window benefits to the same extent, quotes, as if, unquotes, the window benefits had been reduced? Now, Seb's got a slightly quizzical view on his face. Put a slightly quizzical view on his face. Tim, if I understand that question correctly, I mean, what the argument was right the way through in Safeway, that so long as you retrospectively amended in a way which was equal for the past, and so long as you amended in a way that was equal for the future, you were compliant with anything that EU law could possibly ask of you. So if I've understood the question correctly, and if I haven't, please take it up with me offline later. I'd be very glad to do.
I think that's right. And just to add to that, we were trying to run the argument that we were simply reducing through the 1990-60 that which had been levelled up, and therefore we were trying to reduce both the pre and post Barber window benefits to the same degree, but it was a reduction rather than a levelling down.
Yeah,
that argument didn't go much further than the CJEU.
Yeah, but you know, obviously we had to accept, we said, the effect of Article 119 and what we could do retrospectively. And then Tim asked, why didn't Article 119 close the Barber window? This is retrospective. This is a rhetorical question. The answer surely is that Article 119 per Collarol, and unlike Section 62, does not override pension scheme rules. Or perhaps to put it slightly differently, if I may, Article 119 has direct effect, and to that extent it does override pension scheme rules, but it doesn't actually put anything into the domestic pension scheme which can be described as a measure which actually prevents Article 119's continuing operation. Article 119 itself doesn't close its own window, otherwise there could be no such thing as a Barber window. But Section 62 did. So the argument ran as accepted by the Court of Appeal because it did bung something into the scheme rules which had that effect. Then there's an anonymous attendee, very wise being anonymous, for schemes with a carriage style restriction that can be overcome by member consent. And where member consent is given, will an amendment to equalise NRDs take effect from 1196? Does EU law prevent an earlier date? What an excellent question. What do you say to that, sir?
Yes.
Yes to the first half. What about the second half?
No. Yes to the does EU law prevent an earlier date.
So it prevents an earlier date, but what about an amendment to equalise NRDs taking effect from the 1st of January 96 with member consent? The answer is yes to that too.
Yes. Yeah.
So thank you very much, anonymous attendee. The answer is yes and yes, we think. Okay, well, that's the questions. So what remains for me to say, if you'll just bear with me, is, well, first of all, thank you so much for attending. I hope that you found it useful and worthwhile doing so. As I say, we got up to about 142 participants at one point, which was very nice, and we're still at 135. For anyone who recently missed the APL webinar on the Corporate and Insolvency Governance Act, I'm asked you to keep an eye out for an invite to a Wilberforce webinar discussing that subject on the 3rd of August, which will be delivered by David Pollard, Tom Robinson, and Rachel Earle, and invites to that will be sent out, I think, this afternoon. For anyone who attended the pensions lectures in June, talk papers will be circulated to all attendees over the coming week. And finally, if you've missed any of our recent webinars, including the pensions lectures, the Newgy lectures, or the Univar Hot Topic webinar, you can watch them on our YouTube channel, and there's a link to that on our website homepage. So all that remains for me to do is to thank you all once again very much for attending. Hope you've found it useful, and Wilberforce Chambers hopes to see you again sometime in the near future. Have a good day. Bye.